In this video, we will conclude our look at the buyer's rights and remedies where the seller breaches by making a non-conforming tender of goods that the buyer chooses to accept by examining the limited circumstances under which a buyer may revoke its earlier acceptance of the seller's goods. As we have said, under 607 subsection 2 of Article 2, generally, a buyer who accepts may not later reject those goods. But that is a general rule, subject to an exception which is set forth in Section 608 of Article 2. 608 is another example of Article 2's sometimes poor or at least inefficient statutory drafting. But the upshot of its three subsections is that under very limited circumstances, a buyer can revoke its acceptance and thereby reject goods that the buyer has already accepted. But the circumstances are quite limited. Several things must be true before a buyer can revoke its earlier acceptance. First, the nonconformity upon which the buyer wants to revoke its initial acceptance cannot be just any plain nonconformity. Under subsection 1 of 608, it must be a nonconformity that substantially impairs the value of the goods to the buyer. So, whereas the perfect tender rule might have applied to the buyer's original decision to accept or reject the seller's nonconforming tender, upon acceptance, the heightened standard of substantial impairment applies to the buyer's right to revoke her acceptance. Even then, even if the nonconformity substantially impairs the value of the goods to the buyer cannot revoke unless, under subsection 2 of 608, the buyer gives the seller notice of its revocation within a reasonable time after the buyer discovers or should have discovered the nonconformity. And even then, revocation is only permitted under subsection 2 where there has been no substantial change in the condition of the goods other than any changes that may have resulted from the substantially impairing nonconformity. And even then, the buyer may not revoke unless, under subsections 1a and 1b, the reason for the buyer's initial acceptance was that because either the buyer reasonably assumed the nonconformity would be cured by the seller, perhaps because the seller promised a cure, but that substantially impairing nonconformity has not been seasonably cured, or the nonconformity was difficult to discover and that difficulty reasonably induced the buyer's initial acceptance of the goods prior to discovering the substantially impairing nonconformity, or the seller assured the buyer that the goods were conforming and those assurances reasonably induced the buyer's acceptance prior to discovering the substantially impairing nonconformity. So at least four things must be true before the buyer has a right under 608 to revoke its earlier acceptance of the seller's goods. But where the buyer has the right to revoke, and does revoke, under subsection 3 of section 608, the revoking buyer is in the exact same position as a buyer who has rejected the goods initially. That is, the revoking buyer has the same legal rights and obligations as a rejecting buyer. Note, however, how the buyer's right to revoke an acceptance compares to the buyer's initial right to reject a non-conforming tender of goods. From the buyer's perspective, the rules governing its initial right to reject are much, much more favorable. As we have noted, as a general matter and subject to exceptions and limitations, the buyer's initial right to reject is defined by the perfect tender rule. Any deviations from the requirements of the contract, any nonconformity gives the buyer the right to reject the goods at the outset. By contrast, revocation of an acceptance is quite difficult, though not impossible. As a practical matter, this means that a buyer is in a much better position if she can reject goods for a nonconformity at the outset rather than try to revoke regretted acceptance ex post facto. Revocation is unlike rejection in one other interesting regard. Remember, in the case of rejection, a buyer may effectively reject goods even if the buyer has no legal right to reject. That is, even if the seller's tender was conforming, the buyer may reject the seller's conforming tender of goods even though the buyer was contractually obligated to accept and pay for those goods. Stated differently, in the context of rejection, a buyer may effectively make a wrongful rejection, which would put the buyer in breach of the party's contract. By contrast, in the case of revocation, the buyer may only revoke if the buyer has both the legal right to revoke and gives timely notice to make revocation effectively. Stated differently, if the buyer does not have the legal right to revoke, then the buyer's notice of revocation is ineffective. It's not wrongful, it's just inoperative. There is no such thing as wrongful revocation. Where the buyer does not have the right to revoke, any attempt to revoke her acceptance is simply invalid. Upon an effective revocation, however, as we said, the revoking buyer is in the exact same position as a buyer who had rejected the goods initially. which enables us to complete the diagram that we have been using for the last two modules, the diagram that summarizes the buyer's rights upon a non-conforming tender of goods. Where the buyer accepts the seller's non-conforming tender, the next question is, does the buyer have a right to revoke its acceptance and reject the tender instead? If the buyer does not have the right to revoke, then the acceptance is final. The buyer must still pay for the goods that it has already accepted, though the buyer may still have a claim against the seller for the seller's breach. If, however, the buyer does have the right to revoke, then the next question becomes, did the buyer in fact revoke effectively? Because as we have noted, a revoking buyer is in the exact same position as a buyer who rejected the goods initially. She is entitled to withhold any payments owed to the seller under the party's contract and cover or seek market-based damages for substitute goods. Otherwise, in the absence of a revocation, the buyer has accepted the goods. So that concludes our look at the buyer's remedies in the event the seller breaches by making a non-conforming tender of goods that the buyer chooses to accept. And it also concludes our three-part look at the buyer's remedies generally. We looked at the buyer's remedies when the seller breaches by failing to tender the goods altogether, as well as when the seller breaches by making a non-conforming tender that the buyer rejects, a scenario that we saw bears many similarities to the first, where the seller breaches by failing to tender the goods. And in this week's module, we consider the buyer's remedies when the seller makes a non-conforming tender that the buyer accepts. In the next module, we will conclude our look at remedies and indeed our examination of Article 2 altogether by looking at the other side of remedies, specifically, what are the seller's remedies upon the buyer's breach?